Hi folks, Dave here. Um, now, I'm trying out a new program here, so hopefully it'll be kind of an interesting way of doing it. But what I want to do is, I've got something. What's going on, Louis? You coming out? You coming out? Sorry, it's one of my parrots. I have a parrot that loves to sit in my shirt, and he spends most of the day there. So I apologise for his presence, but he is very needy at the moment. So I'm letting him cuddle up because it's a bit cold. Um, Here he is. He's wondering who the hell I'm talking to. Okay, so you can ignore the parrot for a minute. What I want to do is to show you the way I think out legislation. In other words, how do we apply an act to an actual problem that we've got. Now, first things first is you start with the facts, and it's very important that you've got to get a concept of what the facts are. And I reckon the way to start that is by looking at developing a timeline. Now, I like to illustrate mine a bit, and you can pick pictures off the net really easily, and just gives you kind of a feel of who everyone is and what the process is that happened. So you need to have, with any legal problem, that's the first thing you do, is work it out so that you've got that the process, who's involved, who are what they call the parties to the event. Here you've got, obviously, you're going to have a boss of some sort, and the boss is sort of mentioned in there, who instructs an employee. And there's the operators of the excavator and two other truck drivers are assisting the employee. We pick out the fact that the bucket is new. Okay, so what happens? We say, well, in order to understand what happens, once again, the net's very good at that, because it really helps for you to think out what is going on with the problem that's presented. You have to do this in the field anyway. So if you're planning on operating as a health and safety consultant or officer in an organisation, you really need to get your head around how things are done to predict where they're likely to go wrong. Okay, so in this case, you've got what's called the chicken bar. Pardon me. I can't figure out. I couldn't find a picture of a chicken bar. All I got was places that sell chicken. I looked it up, but I assume it's a little bit like this. It's a bar which has at its bottom end, it's like just a single piece of steel, which there must be a handle on. So I've got this as a handle, and they put it up against the pin, which is here, and they bang the hell out of it with a big sledgehammer here. And in doing so, they drive that pin out, and they can then replace these bits, which are the bits that get most worn out, if you like, when you're using a bucket. So, the rest of it's not going to be too problematic, but you need to have these teeth, or picks, as they're often called. They will wear out from being, dragged across rocky ground and so forth, and you'll need to get new ones so that they're sharp and they withstand things. Now, the problem here lies in another force. So hang on, let's go to the next. So the employee had removed two pins using the chicken bar method, right? When you decided to hit the pick on the corner of the machine bucket to loosen it for removal. So the idea is he says, okay, well they get stuck in. So what I'll do is I'll give it a bit of a whack, and that'll get rid of any rust or stuff that's going to be problematic. And it was his practice to hit the pig square on the face to try and loosen it before removal. So he goes ahead and does it, and he's probably done it 50 times before. But there's a trick for beginners here, and that is that the the mallet that he hits it with is made of hardened steel, right? The picks are made of hardened steel. I think that's the way it goes. Let's have a look. Yeah, yes, it is. And the consequence is if you hit hardened steel with hardened steel, then it can shatter. Either one can shatter. The mallet can shatter. The pick itself can shatter. Mild steel, on the other hand, on the other end of it, actually isn't so bad because it'll you can put a dent in mild steel. You can't put a dent in hardened steel. It either shatters or it doesn't shatter. Mild steel, it'll deform. So that's something we need to know. Like, that's something that we really need to get our head around, and you can look that up on the internet and find out the difference between the two as well, if you like. Now, as the employee hit the pick with the steel sledgehammer, a shard of metal splintered off. So I found what might be a shard there. Splintered off the pick and entered his left leg inner thigh, and I've got a picture of what looks like a fairly nasty wound on the left leg inner thigh. Okay, let's have a look and see. So you see the picks are teeth. There's the pins. The picks or teeth are there. There's a pick, a picture of a pick, a pick of a pick there as well. Now, so to start off with this, we've got the quarry manager, and this is the main timeline. The quarry manager tells the employee to drop the picks off for personnel at the site to change them at their leisure, right? So this guy takes his ute, he loads it up into his vehicle, and this particular bucket had never had the picks changed because it was brand new. He puts the chicken bar up, whacks it with the sledgehammer. He manages to get 2 pins out. Yep, 2 pins out, but then he hits the next one, I guess the third pin he's trying to get out. He hits and it splinters and shards out. So that's really the factual scenario that we've got. There's other things like he gets taken off he doesn't go straight to hospital, and it's a bit of a long period of time between it happening and him finally getting it sorted out. And when they looked at it, they found out there wasn't just one shard, there were 2. And also they hadn't noticed, and a lot of people are unaware of this, but running down the inside of your thigh is what's called the femoral artery. In fact, it's femoral because it runs down the femur, which is the main top bone of your thigh, or the only bone in your thigh. Femoral artery is it's very close to the surface, to your skin, and if you injure a femoral artery, you have what they call an arterial spurt, and you can bleed out in 3 minutes. So it's an incredibly dangerous thing to have something pierce the near the femur or near the femoral artery. Extremely dangerous. So that's going to be important later when we look at what they did and what's the risk, what's the hazard, and what's the risk of the hazard occurring. So let's go back a little bit and think about this. So one of the things we have to first of all look at too is what's the structure of the organisation. You might have an owner at the top, or a number of owners. Might be a publicly listed company, for instance, where you've got shareholders are the owner of it. You've got the quarry manager, and then you've got the employees down the bottom. There's usually many more employees, and there are managers, and many more managers, and there are owners. So that's why it's in a pyramid shape. Okay, so now let's go through this, thinking about it from the point of view of the act itself. Well, what bits of the act? And this whole exercise is nothing more than to get you to think about the act itself, okay? And how the act is actually presented. So first bit of the act to look at, and I'll show you, I've got the act here. So I always like to have it open on my desk so I can see it. So start off with the title, the Work Health and Safety Act. That's cool. That's the one. 2012. I always download it directly from Australia. Because in the consolidated acts at Australia you'll find whatever they've got there will be the most recently updated act that you need. Cup of coffee. Okay. Now you can tell a lot about an act by looking just through the titles, the beginning of it, the contents, table of contents. We're going to need, now let's have a look and see, I'll highlight this for you. Where's my highlighting pen? There we are. Okay, use yellow because I'm a coward. No, that's not true. Okay, one of the things you're going to need for sure is definitions. So these are sorry, what it's doing to me there. Definition, subdivision 1 is always important. The other thing that's always important is interpretation. The other thing that's really important is the object of the act. What's it trying to do? You see what I mean? The Division 1 introduction, a short title, you don't need to worry about too much. It doesn't really mean anything. Subdivision 2, other important terms, is obviously going to be very important too because it has in it meaning of person conducting a business or undertaking. So that's important. Meaning of a worker, that's going to be important. Meaning of a workplace, and they've got examples and notes at the end of that as well. Okay, so now go further down. What's the application of the Act mean? Well, you remember we've in previous lectures we talked about this concept of a jurisdiction. The application of the Act is very important to know whether or not you're dealing with this jurisdiction. Now, if this happens in South Australia, then none of the other acts around Australia, other than, say, a federal act, will have any application to something which has happened in South Australia. So this one, so happens that this is a Workplace Health and Safety Act of 2012 for South Australia. Okay, so that's cool. That's all right. So it also says the Act binds the Crown. It tries to. All that means is that people who are working for the government are still covered by this Act. It tries to get what's called extraterritorial application, which means it wants to apply to anything like a ship or boat or whatever that's on the seas but is registered in South Australia. That applies to them. Now, part 2, of course, is the meat and veggies of the Act. So part 2, we've got the principle that applies to duties, okay? And that's very important too. Now, rather than keep going through and through, you see what I'm trying to do. I'm looking at each one and saying, oh yeah, that's probably principles that apply to duties. Duties not transferable. Okay, we won't look at that just here because there doesn't appear to be anyone trying to transfer a duty. Persons may have more than one duty, not so important. More than one person can have a duty, probably all right. Managing risks, that's going to be a big one, right? Because it's a lot. All of this comes down to managing risks, Then it's got what is reasonably practical. Now, what the hey? What are they saying that about? That's a big one. What is reasonably practical? Practicable, I should say, in ensuring health and safety. And the reason they do that, the reason they pick that out, is because the principles, the subdivision principles that apply to duties, will have that statement in it. Something that the standard will be what is reasonably practicable. Okay. Then there's this is a big one. Primary duty of care. Here's 19. So Division 2 tells you the primary duty of care. 19 is the primary duty of care in more specific things. Now, Division 3 is much the same. Further duties of persons conducting business or undertakings. We'll have a look at those if we if it looks like the others don't cover it entirely. But this it's a little bit different. You can see when you look at them, there's persons conducting business or undertakings involving management or control of workspaces. Yeah, well, that might be. Let's highlight that anyway because there is a workplace there. There's a quarry. So, duty of persons conducting business or undertakings involving management or control of fixtures, fittings, or plant at workplaces. Yeah, maybe the plant bit. What do you think, Louis? Yeah, do you like this? Do you? Okay, he says he likes it. Duties of persons conducting business or undertakings that design plant substances or structures. Now, it's a long shot, but somebody designed that front end loader and someone would have been aware. So I'm going to have a look at this. I'm going to, whoops. Yeah, so what am I supposed to do there? Right. There we are. I'm going to just pencil it in. Now, look, I'm going through every little bit. I don't expect this to be on your assignment. I just want the big, broad issue kind of stuff. Like, the Division 2, primary duty of care. You can make a sort of little statement about that. No worries at all. You don't have to go into this, designing a plant and everything. So, but I'm just showing you how you might just go through and highlight it. Importing plant, undertaking the plant supply, duty of persons conducting business of undertaking that install, construct, or commission plant. Nope, that's not obvious here. Like if it had been a person had put a boiler in, would it be then that that would be an undertaking to construct or commission a plant or structure? Oh, you don't want to go to bed? Okay. Duty of officers, workers, and other persons. Now, we definitely know duty of workers. Duty of other persons at the workplace. Yes, there were other persons at the workplace, so maybe it's important. Now, we're not going into offences and penalties. Incident notification, not too worried about that. Authorisations, consultation, multi-business work groups, election of health and safety representatives. Nah, look, health and safety committees. Well, you might, but look, if you're doing a really detailed look at the whole thing, you'd obviously have to go through each one of these to see if they how they do. Issue resolution is one that's interesting. Right to cease or direct cessation of unsafe work. That's important, but probably not for what we're looking at here. Provisional improvement notices. Nope. Okay, discriminatory, coercive and misleading conduct. Doesn't seem to have happened. I can't see any evidence of that in the facts. By the way, when you deal with a fact-based scenario, there's a rule in law that's incredibly important, and that is that you take the facts that are presented to you in a legal problem, you take them on face value that those facts are true. You can't argue the facts in a case. The facts are given. You have to you take them as they are, and that's what you get. I'm chewing gum. Sorry about that. Probably comes up on the microphone, but it's either that or smoking cigarettes, and I'm not allowed to do that. Dealing with disputes, general, the regulator, functions and powers of inspectors, powers relating to entry. There's a heap there that we're still looking, don't forget, here at just the table of contents. So, none of it really review of decisions, general matters. None of that really pokes out as being a fact that's been brought up. Regulations can be important. This little bit here, Division 3, is a bit of a kicker because it says, it shows you how you can make regulations. Regulations are different from legislation. Legislation has to go through the Parliament, and regulations don't in general. Okay, I had to take Louis back to his couch as he wanted some time off. Snorting. Okay, sorry. So look, I won't go through any. I mean, there's. Just having a look to see. There's nothing really. The Mining and Quarry Occupational Health and Safety Committee. Just bear that in mind. I don't expect. I mean, it just is something that comes up. You look at it and you go, yeah, okay. Regulation making powers is always important. Can they make a regulation? But this is fairly deep stuff. You know, you're going to really to understand the greater depth of the Act itself. You're going to need a lawyer who understands the interpretation of legislation and what they call the rules of ultra vires, which are the rules demonstrating where a person tries to make a regulation who doesn't have that power to make that particular regulation under the Act itself. So if anyone wants to make a regulation, any department usually it is, wants to make a regulation, they've got to do it within the confines that the particular God, I've lost it. Within the confines of the powers granted to them by the Workplace Work Health and Safety Act. So it goes on. Don't worry about this. Transitional provisions. Okay, so now we're into the main part of the Act. Let's have a look at this Act here. What's it saying? So the main object, now this, I reckon, you don't ever dismiss the very beginning of an Act, basically, particularly the object of the Act, right? I've got a slide on it, so no, here we are. Yeah, the object of the Act. The main object of this Act is to provide for a balanced and nationally consistent framework to secure, should have made that pink as well, the health and safety of workers and workplaces by A. Protecting workers and other persons against harm to their health, safety and welfare through the elimination or minimisation of risks arising from work or from specified types of substances or plant. So we know that specified types of, that's, let's just get this a little bit bigger so I can do it with the legislation itself. How am I going to get this bigger? Come on, you. Oh yeah, there we are. There's a bigger button. Okay, so if you're looking at it like this in the Act itself, just taken out, it's designed to protecting workers and other persons against harm to their health, safety and welfare through the, and this bit here is interesting because, let's do that in blue, through the elimination or minimisation of risks arising from work. Now, very important that's really the crux of a lot of the important part of the Act itself. It says what you've got to do first up, and this is your duty, this is the object of the Act, this is why we have the Act, that's what the object means, Why do we have it? Well, the whole idea is that it's to, and you could do this, protecting workers and other persons. The trouble with all of these things, you end up underlining everything. Against harm to their health and safety and welfare through the elimination or minimisation of risks arising from work or from specified types of substances or plant. Plant means, for you who are unaware of it, there's some of you speak English as a second language. I only have one language, which is English, and I'm not very good at it. So I admire your ability to master two. But plant is, in this context, means generally machinery. So this the front end loader that they're using in this problem is comes under the concept of plant. Then it goes on and it says it's providing for fair and effective workplace representation. We're not worried about that. The problem doesn't talk about anything to do with workplace representation. Doesn't talk about encouraging unions, which is this bit here. Promoting the provision of advice, information, education and training. Yeah, that probably fits what we're having to look at. Securing compliance with this Act through effective and appropriate compliance and enforcement measures. Yeah, okay. Ensuring appropriate scrutiny and review of actions taken by persons exercising the powers of performing functions under this Act. Yeah, fair enough. Maybe. You see, I'm not sitting here. Whatever you do when you're reading this sort of stuff, don't sit there and think, oh, what do they mean? Ensuring appropriate scrutiny. Oh, maybe he didn't have the appropriate scrutiny and he's in breach of number division 2 subsection 3 object subsection 1 subsection F, and people get caught up in this kind of minutia, the small bits of a problem. Never get caught up in the small bits. Small bits are for lawyers in court, right? Big bits are for us as practitioners. We need to think of the big bits. And the big bits are this. It's protecting workers and other persons through elimination or minimisation of risks arising from work. Do you get the idea? Cool. I feel like I can actually see you. Who's asleep over there? Someone's asleep. With the lectures, it's pretty cool. You can see if people are falling asleep. But with this, I have to assume you're not. Right. Okay, and then they've got this sort of overall thing here, and that really is very good. So regard must be had to the principle that workers and other persons should be given the highest level of protection against harm to their health, safety and welfare from hazards and risks arising from work or from specified types of substances or plant, as is reasonably practicable. God damn, that's that thing that's coming up again. What the hey? Like, make that one green. So that's interesting. We keep seeing these recurring things. As it turns out, reasonably practicable is a term that's commonly used in all aspects of workplace health and safety. The reason is because it's some things you just can't eliminate the hazard. Sometimes it's just not, some things, for instance, like electricity, are innately hazardous. Some chemicals are innately hazardous. The risks, given a particular type of, a thing like, for instance, I worked for a long time with helping out the power industry in Victoria, and I taught in every one of the bits and pieces in the power industry, the distributors that sent it out to your house, the transmission company that transmits the raw power, if you like, from the generators, and I worked with all the generators as well. Over a period of about 2 years, I taught about 1,000 people or more, it might have been. It was very interesting to see the application of the law regarding this. I wasn't doing health and safety in those days, but of course they were worried about it. I was looking more at the contracting out different functions. But if you've got just one little thing that always pops into mind, there are people who work on the two different types of power. There's what they call HV and LV. High voltage, HV, and low voltage, LV. Low voltage is what comes into your house, and high voltage is what takes the power from the where it's made, if you like, the generator, through to places where it's then distributed out. And people worked on the high voltage were in a situation where it was just extremely risky, because you're dealing with hundreds of thousands of volts of power going past you, and you've got to grab hold of cables and do them. In fact, a lot of HV work is done while the cable is live. So they have a phenomenal, uh, thing which they do. That the stuff they do is quite, you look at it and you go, you are kidding me. They have these enormous rubber gloves that are so big you can hardly move your hands in them, and they've got, sometimes they actually put themselves in a kind of chain mesh sort of suit almost, and they lock themselves onto the high voltage cable so that there's no difference between them and the high voltage. So basically they're able then to touch the HV without it jumping from one point from a high voltage to a low voltage thing. It's extraordinary. I never really understood it well, but I tell you what, I'd never do it. Anyway, so the trouble with those is that it is impossible to eliminate the hazard other than just shutting the entire system off, and sometimes they do that. But it is possible to decrease the risk. So you've got the hazard is being killed by electricity. The risk is how likely is it. They can reduce the risk down to almost infinitesimal points, and they might lose a worker every year or 2 years, which is still far too much, but it nevertheless, given the number of hours that they spend working on high voltage lines, is pretty damn good safety record. Although really we should all be aiming for zero. But sometimes it's just not reasonably practicable, and that comes up, and we got the same thing looking at this, was how they took the teeth off the dozer. That was obviously a hazard because it happened, right? What's the risk involved in that hazard? Well, we have to sort of estimate that, look what the risk is, and was it reasonably practicable to decrease that risk, or was it possible to eliminate the risk? And we'll find out in the facts that in fact it is possible to eliminate the risk. Maybe not. We'll come to that anyway. Maybe not. Okay, so now I'm going to go back to the sheet on the problems here. Right. I'll put this thing up for you. Hopefully it should be there. It's a bit higgledy-piggledy, but it gives you some idea of what's going on. Okay, so we've done that picture, we've done that. So how does it all happen? Well, you got the boss, the employee, the operator of the excavator, and 2 other truck drivers assist this employee. So there's 4 people helping to do this. The bucket was new, it hadn't been done before, although the person who took the teeth out had taken teeth out many times before, and one assumes well, in fact the facts say that this person, who happened to be a male but could have been a female, in this case was used to do it before, and in doing it before it had obviously, well, imagine anyway, unless they're really stupid, has never had a shard break off and get him in the leg before. Otherwise I guess I wouldn't do it. Now the facts tell you what it is you should do to stop that, and that is you have a system which says, or part of your safety thing says, never hit a hard steel item with a hard steel item. So don't clash 2 hard steel items together, because they're liable to shatter. So what you do is this could have been fixed completely, would have stopped it being a problem at all if they used a different type of mallet or a different type of tooth, or pick as they're called. So they had a different type of mallet. How would you do that? The mallet that they would have would be what they call a composite head to it. Composite heads, basically it's a plastic mallet, okay? It's still incredibly tough and very, very strong, but it's a composite upon which means that it gives rather than splinters things. The other way of doing it was to say no. See, that might be problematic because workers being workers, as every individual is, we don't always do what we know we should do, and if we've got to get a job done quickly, we'll go, oh, she'll be right, mate, we'll do this. We'll just give it a quick whack with this. It's probably not going to splinter, and bugger me, it does. And I wouldn't be surprised if the worker in this case was aware of the fact that hitting hard steel onto hard steel is probably not a good idea, but just sort of thought, oh, well, it hasn't happened before, so it probably isn't going to happen again. Big mistake. So if that person the employee had a composite mallet, the likelihood is they would have used that. You can make it a very strong regulation, never hit the steel if you're removing pins. Only use a composite head mallet or a mild steel mallet. I'm not actually sure they make mild steel mallets, to be honest with you, but anyway, if they do, use one of those. Now, you still got the problem, though, that a worker might be new to it, goes and picks up a mallet. The guy just says, oh, Jack, go and get the mallet, would you, so we can knock these pins out. And so Jack goes off, gets the mallet, comes back again, doesn't think twice about it, gives it a bit of a whack to loosen it, and spring-o, out comes the shard and bites him. Now, which could kill him quite easily. And so having two different types of mallets could be confusing. The other way around fixing this problem, which is mentioned in the facts at the end, is that you could have the type of teeth, of picks, these type here, which are screwed. They're held in by screws, so you unscrew them, and that way you don't have to bang anything with them. I couldn't find a really good picture of what a screw type looks like, so I'm as yet still in the dark. So, okay, so we've done that. What's the difference between hardened and mild steel? I've said, well, the difference is that, and you can look that up, but hardened is generally, it's much harder, obviously. It doesn't give when you whack at one, but mild steel does. You'll get dents in a mild steel hammer, for instance, if you use one. But they don't splinter. The mild steel ones hold together. It's a different molecular structure. It's a different process for making it in a way. I think they superheat the hardened in order to, or they heat it a number of times. I think that's the way it goes. Okay, first thing I looked at here was the meaning of workplace. Well, I've got to know what the workplace is. So in section 8, see if we can find that, meaning of the workplace. Whoops. One of the things you can do is look these things up. Meaning of the... Where have we got this? Okay, so if you go back to the Act again, you'll see that. So 5 is the meaning of the subdivision. Other important terms is what we're looking at. Subdivision 2, that's one we're looking at. You can look at the meaning of a person conducting a business or undertaking. Okay, they're going to fit into that, I don't think, with any problems, because obviously that's what they're doing. Meaning of supply, don't worry about that. Doesn't have any. The meaning of a worker can be important, which is the person is a worker if the person carries out work in any capacity for a person conducting a business or undertaking, including work as an employee, right? What about remember there were a few other people there as well. There was a couple of truck drivers and the guy who was driving the front-end loader. They could have been contractors, still covered. An employee of a contractor or subcontractor, still covered. An employee of a labour hire company has been assigned to work in the person's business or undertaking, still covered. An outworker, the person who's, I don't know, whether they define that or not. An apprentice or a trainee. A student gaining work experience. A volunteer. A person of a prescribed class, which comes up later on. For the purpose of this Act, a police officer, well, we're not worried about them. Person conducting the business or undertaking is also a worker if the person is an individual, carries out work in that business or undertaking. Don't worry about that. Is the quarry, though, a workplace? So a workplace is a place where work is carried out for a business or undertaking and includes any place where a worker goes or is likely to be while at work. Well, that's pretty straightforward, okay. So definitely that covers a quarry, don't you reckon? In this section, it includes a vehicle, vessel, aircraft or other mobile structure. Yeah. Any waters and any installation on land, on the bed of any waters or floating on any waters. Well, those are for obviously things like, what if he hurt himself in a car or in a boat? That was part of the duties. So yeah, don't worry about that. It's not important. We know he's definitely is a workplace where work is carried out for the business of undertaking, blah blah blah. So that's all right. Application of the Act, okay. Nothing there. Extraterritorial is nothing there. Extraterritorial is not what this is. It's not a South Australian ship, for instance. Provisions of this Act are in addition. Now this is 12 is really important in terms of understanding the Act, right? Section 12, the provisions of this Act are in addition to and do not derogate from the provisions of any other Act. What does derogate mean? It means subtract from, take from, okay? So all of the requirements of this Act add on to any other Act. So if you've got a duty under another Act, like the Mining Act or whatever, this adds on to it. This is both of them apply. And this is a really interesting one here, is when we were doing the bits about, if you remember, sorry, what am I on? What colour am I? Green. Why didn't that change? Blue. Okay. The provisions of this Act do not limit or derogate from any civil right or remedy, and compliance with this Act does not necessarily indicate that a common law duty of care has been satisfied. So now, what the hell does that mean? Well, you remember, if you go back to the original lectures that I gave you on the difference between common law and legislation, and I told you about the case of Donoghue and Stevenson, so in which we're looking at the law of negligence. In South Australia, this Act, the Work Health and Safety Act, does not take away your right to sue civilly. In other words, to sue for negligence or even something which isn't negligence but is still civil. So sometimes it's just, most of the time it's negligence, but occasionally you get a deliberate act of a person resulting in injury, and that's a battery or an assault. And you can see for that, those are two. Battery and assault are not just criminal provisions, there are also provisions under the civil law, which allows you to recover damages for somebody assaulting you, for instance. But most of the time it's going to be negligence. So provisions of this Act do not limit or derogate from any civil right or remedy. That's the first thing that's really important. And this is a really, make this one pink, and compliance with this Act, right, and compliance with this Act does not necessarily indicate that a common law duty of care has been satisfied. So even if you do all the things that the Act tells you to do, you are still open, and this is the organisation, they don't generally sue individuals, this is the organisation for whom you work, is still liable to the possibility of an individual or someone else, another organisation, suing in civil law for as I said before, for any civil right, which is basically negligence, okay, or a tort is really what it's about. And when it comes to this kind of area, and the fact that you can't turn around, you can't plead against that by saying, hey, like I did everything that the Act said. I did this, I did that, I did this, I did that. Well, all this provision says is, hey, that might satisfy your duty of care, that you've done it all. Although I'd say in a lot of cases it would, but it doesn't necessarily do that. You can't wipe your hands of what it is you're supposed to do just by saying that I've complied with the Act. Now, this I think is one of the strongest arguments you can use to get change in an organisation you're working for, because my experience is that there's a bit of a fight between two people involved in this, right? There's a fight between the accountants on one side of the organisation, and on the other side, you've got the people who work health, safety, and the employees, right? Now, the accountants, which is what they're paid to do, although they are generally a pack of immoral bastards. No, I'm only joking. They, they'll be saying, look, it's too expensive to eliminate this risk, right? Now, I always use this. I say, look, it's a very brave decision, to the accountant. And the accountant says, what do you mean? What do you mean brave? And you say, well, I mean, yeah, you might save, $1,000 now, but imagine how awful it's going to be when someone is injured and sues you for over $1 million, sues the company for over $1 million. Do you seriously suspect that you're still going to be having your job on that day? And they go, yes, okay, I've been thinking about the $1,000. I think that should be spent now. So it's a really good point, because if there's a risk, and even if it's a relatively remote risk, but the consequence of the risk is major, like this, it's a small risk. Looks like as a hazard, it's only a little hazard. It hasn't got. It actually has quite a high risk value, because hitting hardened steel with hardened steel generally ends up bad news. So the thing to remember is that not only can that person recover under the workers' compensation, or you'll get sued under workers' compensation, or not sued, it's a bit like criminal law, so you'll be prosecuted under the Act. The organisation will be prosecuted under the Act for not having done what it's supposed to have done in the first place. That's the first thing. But the second thing that's major about it is that you could be sued individually on top of, in a civil remedy of negligence, for the damage which is caused. Now, if you've got, people look at it and say, oh, he only got a hole in his leg, But if, for instance, that had been just quarter of an inch or a real inch, by the way, it's a real case, okay? I stole this case from a case report. And so all the facts are exactly right. I think I changed the names, that was it. But if that shard had gone a little bit further, and they'd ended up with a major bleed, and he had bled out and died, that's one thing that could have happened, and that's actually a cheap option for civil liability, because when a person's dead, they don't cost anything. Say he bled out and got, as a result of not getting enough oxygen to his head, before they managed to stop the bleeding, ended up with a brain injury, acquired brain injury. That could be millions of dollars in a civil suit, because you've got to put the person back in the position they would have been had the act not occurred. Now, that would have been, a person would be earning, whatever, 50, 60,000, say, a year working in the quarry, maybe more. There's that times the number of years he would have generally been expected to live. Say he's a young guy, he's only 22 or something like that. You could have another 40 years, depending if that puts the retirement age up, maybe 45 years. And then on top of that, you've got hospital costs, getting him back online. These civil lawsuits where a person's really badly injured and still alive, or invariably add up in the millions. Now they're paid by your insurance, obviously, or the insurance of the company, but yeah, I mean it's a lot cheaper and it's a lot nicer. It's better for people to work this stuff out and do it properly. You know what I mean? Okay, I'm going to take a short break and then I'll be back. Okay, testing. I've changed microphones so you haven't got me chewing gum in your ear, which I think would be extremely annoying. Okay, so the next one that we're looking at now is section 17, and that's section 17. What subdivision is it? It's part 2, division 1, and it's number 17, the management of risks. I'll just go through the beginning of it. Principles that apply to duties. So that says, what are the basic principles? Well, first of all, the principles that apply to duties, this subdivision, and the subdivision is division 1, do you get the idea? Subdivision, it's a part, there's parts, there's divisions, there's subdivisions. So this is part 2, division 1, subdivision 1. This subdivision sets out the principles that apply to all duties that persons have under this Act. Okay, then duties are not transferable, so you can't impose a duty that you have. You can't give that to someone else and wash your hands. A lot of people in contract management try and do that. They'll say, oh, you know, that all care will be taken, but we, you know, when it comes to it, in the end, it's up to you. Can't do that. Not with, you can do it in contract law, but you can't do it in this scenario. So you can go into a car park, for instance, and you can contract, and you do contract, the liability, limitation of liability to the person that owns a car park. But if you apply this Act to it, the Work Health and Safety Act, and a car park is a workplace as such, and people who are in it are subject to the same safety precautions that people who work in it. It's just being done it to be a worker to be covered by this. You only have to be there. Duties are not transferable. You can't transfer that duty to another person. And a person may have more than one duty, so any one person in the organisation may have a number of duties. A person can have more than one duty by virtue of being in more than one class of duty holder. Now, you look at it and you think, well, what does class of duty holder mean? Well, class of duty holders, or classes of people in law, means a group of people. So, for instance, a class of people in an organisation might be managers, or all workers. And a person could be both a manager and a worker. They could fit into both classes, in which case they'd have the duties imposed upon managers and the duties imposed upon workers. They could be a subcontractor as well as a worker as well as a manager. I don't know, that it's endlessly possible, but they're trying to catch everybody. More than one person can have a duty, so one duty itself can be split amongst a number of people. More than one person can concurrently have the same duty. Each duty holder must comply with that duty to the standard required by this Act. Now we're getting to the big stuff here, the standard required by the Act. Right? Put that in pink. Even if one duty holder has the same duty, doesn't matter. Each person has to apply this standard. If more than one person has a duty for the same matter, each person retains responsibility for the person's duty in relation to the matter and must discharge the person's duty to the extent to which the person has the capacity to influence and control the matter, or would have had that capacity but for an agreement or arrangement purporting to limit or remove that capacity. Now, what does that mean? They have foreseen the likelihood that what you're going to do is you're going to have some people who are going to try and contract out of having a responsibility. That everybody wants to do that. They try and shift things legally constantly. And everybody tries to do that by having limited liability corporations or by having contracts with terms that decrease liability, what they call limitation of liability clauses, which are in just about every contract. And that's what they try and do. They sort of say, no, don't go to me, man. I'm it ain't me, babe. You're going to go somewhere else, you know. But this clause, 16.3, okay, if a person has a duty for the same matter, each person, more than one person has a duty for the same matter, each person retains a responsibility for the person's duty in relationship to the matter and must discharge that person's duty, and don't worry, we're going to get to what the duty is in a minute, to the extent to which the person has the capacity to influence and control the matter. So in other words, you've got a duty, but it only goes so far as you're actually able to control something. Like if you said to a person, if you say somebody gets injured and you've got a worker, a manager and a board of directors, right? And the manager clearly has the right or has the requirement to carry out the health and safety of workers. Okay, so that's one person with a duty. Now, the only thing is that it may be not possible for that person to influence or control the matter. Now, this is interesting, right? Because you might have a manager who says, listen, the board told me to do that and there's nothing I can do about it. You know, that's the board curtailed my ability to control health and safety and gave it to someone else. Well, this clause says it doesn't matter what they say. If you had the capacity to influence and control the matter, in other words, as a manager, you had the right to say, you cannot hit that pick with that mallet. Do you see what I mean? Or they would have had the capacity, but for an agreement or arrangement purporting to limit or remove that capacity. In other words, say they take a job as a manager and they say, I'm not really happy about taking responsibility for health and safety. I'd like to get that to someone else. So they write this into their contract of employment. Doesn't matter. You're going to be stuck with this section. We'll override all of that anyway. So what is the duty? And this is the real crux of the whole thing, isn't it? I know I keep saying that, but this is it, really. You've got in 17 it shows you the management of risk. So the duty imposed on a person to ensure health and safety requires a person to eliminate risk to health and safety so far as is reasonably practicable. So what have you got to do? You've got to eliminate the risk to health and safety so far as it is reasonably practicable to do so. Now, if it's not reasonably practicable to eliminate the risk, see the difference here? So you've got eliminates here. If it's not reasonably practicable to eliminate the risk of health and safety, I'll give you an example of that in a minute, to minimise those risks so far as it is reasonably practical. They have to minimise the risk so far as it is reasonably practical. Now, what would you envisage that might be? Well, you can eliminate a risk to health and safety, for instance, by, say someone's working in this electrical, so say you're in a factory and you've got electrical wires that go over top, and you also are using a big, what do you call those things, forklift, right? Now, you can say to the person who drives a forklift, never extend your fork above 2 metres, because at 2.5 metres there are live wires and you could easily get killed. So is that eliminating the risk to health and safety?
Well, you can actually eliminate that risk to health and safety by using what they call aerial bundled cable ABC, which is a wire has got covering on it. You know, just like this has a cover on it. Do you get the idea? I can't get a shock off that cover because it's covered in a non-conductive coating. I could also raise the wires to, let's say that I know the forklift is maximum height and the forklift is 2.5 metres. I could raise the wires to 3 metres. Now there's no chance of the forklift touching the wires, right? Or I could make it so that the forklifts can't lift above 1.5 metres. You can adjust forklifts in such a way. I don't know for sure, but I think that's the case. So that would be one way of eliminating it so far as is reasonably practical. It would be considered to be reasonably practical, even though it might cost you a lot of money for a refit of the factory to make sure that the electrical wires are well away from anybody touching them. And there's a guy on very sad story, this week, was it this weekend or Friday, might have been Good Friday. He's working on a building and was lifting sheets of iron up and touched off a electrical cable and ended up being electrocuted and dying, which is very sad. Now that's just terrible. You know, that should never happen, but it does happen, and so that's why the gold standard is to eliminate risk. Okay, do you get the idea? So the gold standard is to eliminate risk. Just leave it at that. If it's not reasonably practical to eliminate the risk, then you have to minimise those risks so far as it's reasonably practical. Now, I'll give you an example. A children's playground always has the risk that a kid's going to fall off something and hurt themselves. But it's not practicable. It is not reasonably practical to make a children's playground absolutely kind of invincible. I mean, I don't know what you'd have to do that, or even if it would be possible. I doubt that it would be possible to make a children's playground completely risk-free. Hang on for a second. Okay, sorry, had to have a quick break. With the children's playground, it's not reasonably practical to eliminate the risks. So therefore you have to minimise them as much as you possibly can. And that includes having sort of low impact ground cover. You know, you can get this sort of bungee kind of coating that you put on the ground. It's like asphalt, but it's, it's thick and it sort of absorbs impact. You can have parts of the playground which, not, if you're going to have something which they climb around in, make sure it's really well designed so they can't fall out the side at sort of 5 foot above the ground. Because a 2-year-old who falls 5 foot is like throwing, an adult out of a 3-story building. And people go on it. One of the things that really annoys me with this thing is where people use the word nanny state. But I'll tell you something, right? I lived in 1972. I went across to work in England in the factories. There was no health and safety of virtually any sort in the factories I worked in. I saw people lose hands. I saw one guy lose a hand. I saw people lose all their fingers in a machine that had no cover on it. I mean, it was the most simple thing you could do to make it so it didn't happen. I saw injuries that are just appalling, and I can tell you, anyone who says those are the good old days never experienced them. It's as simple as that. I just completely ignore them. It's a load of bullshit. If they tell you that it was better then than it is now, they are talking through their bums. Okay. Now, second bit then, a person must comply with subsection 1. See, that's subsection 1 here, which is the one we've just read. Person must comply with subsection 1 to the extent to which that person has a capacity to influence or control a matter, or would have that capacity but for an agreement or arrangement purporting to the limit. We've already gone through that, so you know what that is. So now the question is, what is reasonably practicable? Now, in the end, we're we're in a dark place with this, right? Because this is a brand new act. The use of the word reasonably practicable will have to be decided by case law in the ensuing few years. So to get a clear understanding of what reasonably practical means is going to take a while before it goes through the court system to find out how judges interpret that. But in the meantime, the people who write the statutes have gone as far as they can, probably drawing on previous law, to understand and explain what reasonably practical in this act means. It's only about in this act, you see. You can't necessarily draw the words reasonably practicable from another act and say, oh, well, that must apply here. Now, these are arguments that a lawyer makes, not a practitioner. Not a practitioner of health and safety. It's not our job in that sense to make those decisions. So we have to have an understanding of it, but we really don't want to go through the fine points about what the exact meaning of each phrase is. So, okay, it gives you a few examples. It says, in relation to a duty to ensure health and safety, reasonably practical means means that which is or was at the particular time, that's an important bit, at the particular time, reasonably able to be done in relation to ensuring health and safety, yep, taking into account, don't you just love these, taking into account and weighing up all relevant matters. So that's a that's a mouthful, isn't it? Okay, so it means reasonably practical in relation to a duty to ensure health and safety, and it's the way you say it that gives you the ability to interpret these things. So make sure your commas are very important in the interpretation of these. So, reasonably practicable in relation to a duty to ensure health and safety means that which is or was at the particular time, because often these things have happened a while back, 5 years ago, and so we need to know what's going on at the particular time. What was technology like at the particular time? What did we know about at the particular time to get the idea that the accident occurred? That it was reasonably able to be done in relation to ensuring health and safety, taking into account and weighing up all relevant matters. Now, it says, and this is very important here, all relevant matters. You don't have to, by the way, when I'm saying this to you, and oh God, it's difficult for me because I'm sort of used to teaching lawyers, right? So I expect of them detailed stuff, because normally you'd be teaching this course to a fourth or final year law student, fifth year law student. You'd know that you can say to them, look, they've read lots of legislation. You do not need to understand it this way. You don't need to do this much detail. If you're sitting there thinking, oh my God, I didn't do this with my case one summary, it's nothing like as detailed as this, or whatever, don't do that. It's not the way I'm going to mark it. I'm marking case study one based on being able to see that you actually looked at the act a little bit and got some basic ideas out of it. That's a good credit to a distinction even, right? So relax. You're not going to be beaten over the head, I promise you. Okay, so let's have a look at this. So taking into account, weighing up all relevant matters. All relevant matters means, because it says all relevant matters, including. So it's including all of these here, A, B, C, D, and E, right? But there's any other relevant matter, any other matter that's considered to be relevant, is also having to be taken into account. So let's have a look at the ones they list out anyway. The likelihood of the hazard or the risk concerned occurring. So obviously you identify the hazard. So what was the hazard? The hazard in this one was was a shard of steel coming off the pick and into the guy's leg. It's really just shard of steel coming off and hurting someone. The degree of harm that might result. So the first thing is the likelihood, the degree of harm that might result. Because you see, some things like, you might look at it and say, well, he could have hit his pinky with a hammer by mistake or something like that. Yeah, it's probably fairly likely, but the degree of harm, bugger all, He gets a black nail for a couple of weeks and then he's, not a problem. So, but the degree of harm of this, as we've already established, is actually quite high. And the facts tell us that. They say, had they hit the femoral artery or got any closer to an artery like that, he could have bled out very quickly. Other things you've got to take into account. Number C, what the person concerned knows or ought reasonably to know about the hazard or the risk and the ways of eliminating and minimising the risk. Now, this is an interesting one. What a person knows is what's known as an objective test, because it means it's what a person knows is what they actually know. You've got to get into their heads and say what they know. Do you see what I mean? There's an objective test. A subjective test is to say we don't really care whether you did know it, but a person in your position at that time should have known it, ought to have known. Do you get the idea? It's interesting in criminal law. There's the difference between murder and manslaughter is often this type of test. So for murder, you need an objective test about whether the person really did know that it was likely that the person was going to get injured or not. You can't do it subjectively as easily, although, look, that's... Now I say it's not entirely true, but it gives you a basic principle. Manslaughter, which is much lesser charge, lesser sentence, because murder's just life. It doesn't matter what you do, it's always life in Australia. They might get out after 15 years, but it's unlimited licence, so if they do one break of the law at all again, even speeding, they can be brought back in. So, so for manslaughter, it's often about whether the person did know or ought to have known that their action could cause injury to someone or death, right? So there's a difference of this. So the question is what the person concerned knows or ought reasonably to have known, given their position, given what they do, the hazard of the risk and ways of eliminating or minimising the risk. So you can imagine the guy going in there to court, right? And he says, look, Your Honour, I had no idea that, striking a hardened steel against a hardened steel pick would end up with it shattering. Oh, I just didn't know that, And the court says, well, we don't really care whether you knew it or not, right? You ought to reasonably have known it because you're a manager of that site and that's your job. It's part of the safety, part of the safety system. You should know that. You ought to have known that, given the circumstances of what your job is. You work in a quarry, What you're doing is working with quarrying equipment. You need to know about the hazards involved in using quarrying equipment, which also includes this. Might do. Okay, sorry. Stop the dogs from barking. Yes, so what the person concerned knows. Okay, so we've done, whoops, close that off. What the person concerned knows or ought reasonably to have known about the hazards or the hazard or the risk and ways of eliminating or minimising the risk. So, for instance, if they said, look, I didn't realise you could buy picks or teeth for the dozer bucket that didn't have pins. So, because in doing that, you'd eliminate the risk of shattering because you don't use a hammer to open them up to get them off. The fact that the person didn't know it as a matter of fact doesn't matter because if they ought reasonably to have known it. In other words, if owners of dozers and buckets would do that. And that's a question of fact left up to the judge or a jury in a trial as to whether they ought reasonably to have known it. And that's, it's a question which is, well, it's a question of fact, and all questions of fact are left to a jury or a judge sitting as a tribunal of fact, they call it. So that's another thing I'll tell you about another time. But that's basically it. So it's pretty blanket. It's saying that that if you ask what does that reasonably practicable mean to you as a person, it means you need to know what you ought to know. In other words, what you ought reasonably to know. You have a duty to look at the machine that you use in your daily work and work out what the safety factors are involved in using it. And you also need to know the ways of eliminating or minimising the risk. And if you can eliminate it, eliminate it. If you can't eliminate it, then you've got to minimise it to the greatest extent that you can do. You can't say it's a choice. Oh, I'd had a choice. I either did eliminate it, which I could have done, but that would have been $500 to eliminate it by changing the picks over, for instance. So I just minimised it by getting rid of the hammer and making sure there was a composite hammer. Not good enough. You could have eliminated it. You didn't do it. Bad luck. You can't be said to have been what you did was reasonably practicable. The availability and suitability of ways to eliminate or minimise the risk has to be taken into account. What can you get to change it? How suitable would that be to your operation? You can take that into account, but after assessing the extent of the risk and the available ways of eliminating or minimising the risk, the costs associated with available ways of eliminating or minimising the risk, including whether the cost is grossly disproportionate to the risk. Okay, so now the real guts of the entire thing lies in this part, right? It says, let me just go back a little bit here. So what is reasonably practical in ensuring health and safety? Well, the things that you can take into account are the likelihood of the hazard and the risk concerned occurring, the degree of harm that might result, what the person concerned knows or reasonably to know, the availability and suitability of ways to eliminate or minimise the risk, and after assessing the extent of the risk, because you know what the hazard is. The hazard's the peak shattering. The extent of the risk is what happens if it shatters, right? Extent of the risk and the available ways of eliminating or minimising it, the cost associated with available ways of eliminating the risk can only be taken into account in a situation where the cost is grossly disproportionate to the risk. Once again, this is going to be decided by a court at some stage in the future as to how you interpret grossly disproportionate to the risk. I think it would have been better to have had some sort of understanding about that. For instance, because a lot of decisions, there's a case called Mercer's case, which is very interesting. I'm not sure if I've told you about it before. Anyway, Mercer's case, I think the guy was a tram driver, and he was driving a tram in Melbourne. It was way back in the sort of 1920s or 30s or something. Anyway, Mercer was the guy who was driving it, and the tramways in those days hadn't fitted, or I think the older trams just didn't have a thing they called a dead man's hand. A dead man's hand is where you've got to hold on to the thing to accelerate the tram and decelerate. If you ever let go of it, it springs up and turns the brakes on at the tram, and that's it. Being the idea that if a person dies at the wheel of the tram, the tram doesn't just keep going on and on and on, running people over and banging into cars and buildings and the rest. So that was it's actually a very simple thing. It's just putting a spring on it, basically. So it's not a very expensive mode to do. But the tramways had decided that they wouldn't refit all the trams because they worked out economically it was cheaper not to refit and to pay out any damage that might be caused. So along comes, this guy Mercer that dies. Mercer would have been the plaintiff. So Mercer's the one who's been injured as a result of them not fitting this thing. Somebody driving the tram dies. I think they died or whatever, had a fit. The tram went into them and injured them. And the tramway company said, it would have cost us a lot of money to do it, so we've decided it was better to pay out. And they were sort of arguing that, they were saying, well, they didn't need to pay out. And the court was really funny. The court said, listen, you made a financial decision about this based on the principle that you would save money by not retrofitting to the older trams because it was going to be cheaper. It was going to be cheaper than to pay out. And then you come and see us in the court and you say, I don't want to pay out either. You can't have it both ways, mate. It's one or the other. Anyway, they held against him. I thought it was a wonderful case, a case of intelligence overcoming stupidity. Oh, wow. This is long, isn't it, when you go through the whole act together? What is the primary duty of care? I'm just going to do this bit. Actually, I don't know that there's any use in it. The person conducting comes out. Let's have a look. Essentially, let's go back to the case, right? It's a workplace. We know that. We don't have to worry about that. We know what happened. We know that the Act, this one says the provisions of this Act do not limit or derogate from any civil right or remedy. We know what the PICs look like. We know that we know what the timeline looks like. We know how they made the change. Meaning of a person conducting a business, yes, it comes under that. It's definitely because he's conducting a business. The regulations may specify. So regulations means, just remember that there may be a very specific regulation about putting PICs on dozer buckets. Who knows, right? There might be. So you need to have some sort of understanding. Not for the case study one. I didn't ask you to do regs, but didn't matter if you did, but you didn't need to. Okay. The duties, the basic duties are come down to 17 here. The management of risks, and a duty imposed on a person is to eliminate the risk of health. So we've gone through that. We're looking at the person must comply with to the extent of which the person has the capacity to influence and control the matter. Well, I'd say that the parties here there's no question that they had the capacity to influence or control the way that the PICs were changed, because they made a choice to buy a bucket which had pin PICs on, pin fixings for the PICs. So it'd be very difficult to say that they weren't there. So they had the ability to change it. What's reasonably practicable? Just been through that. Weighing up and these are all the matters that you need to look at, I've gone through all of those there. And that's basically it. You don't really need to look, there's and the facts themselves say it was reasonably foreseeable that striking a hardened steel item with a steel sledgehammer, the steel item could fracture or splinter, and those fractured pieces could come into contact with the operator. So you've got the facts already been held by the court in that, which they actually did, right? Prior to and at the time of the incident, the defendant provided hardened steel sledgehammers for the removal of the PICs. As an additional measure, the buckets could have been fitted with a twist-type teeth, which would remove the need to use a sledgehammer to dislodge the PICs. A reasonable practical measure that the defendant could have taken to eliminate the risk was to ban the use of steel sledgehammers for use on hardened steel objects. I don't like that because my experience of working, and I have many years of working on the roads, As a labourer, I left school at 14 and I started working at 14, basically working on the roads, doing the rolling out asphalt footpaths in Stirling and Adelaide for the council, and then went on to work in a quarry once again near Stirling. And I've had a fair bit of exposure to that. And what you get is generally it's a young man's game, a young person's game, and they're not. When you're 15, you don't think about things like, oh gee, is this a hardened steel object? You don't do that. So the trick is really the only thing that really makes any sense is to put picks in that can't be removed with sledgehammers, that aren't designed to be. That way you eliminate banging this hardened steel thing. As an additional measure, the buckets could have been fitted with twist-type teeth. I think that's the one that really takes a measure there. The measures taken since the incident by the defendant. Now, and here you got it all for you. Banning the use of hardened steel tools on hardened steel items. Once again, difficult one to do. Very difficult one to do. I think just get rid of the hardened steel hammers, because you don't need them. You can do it with the new materials they use much better. It's purchased soft plastic composite hammers for the task of removing picks, and systematically replacing the picks on excavator buckets with the twist type picks, which are easier to remove. What else did they do? At the time of the incident, there was no specific hazard identification. This is where you pull your hair out. Risk assessment in relationship to the task of changing picks on an excavator, and that's common as. Additionally, there were no safe work procedures in place, or any prohibition in relation to striking hardened steel with a sledgehammer. What do you reckon the judge is going to do with this? Go bang! It's like, you what? There was no hazard identification, A proper hazard identification would have alerted the defendant to the danger, blah, blah, blah. If steel sledgehammers had to remain on site, which is, we're not sure, right, but for other purposes, there should have been a specific instruction not to use them for the task of removing picks. Maybe you could stick it on their handles, I don't know. I think it's a difficult one, because you do get, labourers working on it, and you've got to look. When I was a kid working as a labourer on the thing, I did not listen to what people told me. I still have that problem, right? Here I am, 59, still have the same problem, so maybe it just doesn't work. The subsequent banning of the use of hardened steel tools and the preparation of a job safety analysis in relation to the task of changing picks have been appropriate measures to obviate the risk. Fair enough. I think I would have said take all the picks off and change them to the twist type. I don't think that would, the cost of doing that might be a bit, but it's this could have been a death. This could easily have been a death. As of the date of the incident, there were no specific instructions or training for changing picks. This failure to instruct and inform is a natural consequence of the defendant's failure to identify the hazard involved or carry out a risk assessment, and didn't do anything. Since the incident, the defendant has trained its operators in relation to safe work procedures and job safety analysis. It has also informed various industry forums of the risks associated with striking hardened steel items with steel sledgehammers. Now this gives you, it might be that it actually wasn't well known. I'm sure I have heard it before many times, that you've got to watch out with hardened steel because it has a tendency to splinter. Anyway, they're saying that they've getting the information out, so they're good on them. Giddy up, I say. It distributed to its employees safety alerts in relation to the risk. What do you do with a safety alert when you're a baseline employee? You use it to wipe. Yeah, no, I won't say it. But you don't sit there and read them and go, well, this is very interesting, Circulating a memo to employees about the incident. Oh, God, man. anyway, training package is developed. That probably would do something. Training package, particularly about this. The risk of injury was that of steel splintering or shattering and flying into the body of the operator. The actual injuries sustained were at the lower end of the scale. The actual risk posed was that of very serious injuries, such as penetration of an artery, penetration of the face, head, chest or throat, such that a death could result. Now look, that I've deliberately held off marking all the Case 1 studies at the moment. I'm going to do them in a burst of 3 days next week. It's on Monday. Might even do quite a few tonight. I've got about 62 to 60 something to do, so it's quite a bit. But I think you can look at that. This should give you an idea of how it is you might approach Case Study 2 to get the ideas of what bits of the act you're going to actually pull out and look at and what factual things you're thinking of. That's what Case Study 2 is about. And then the major essay is really putting that in a form that will get and convey the information across to a person you're trying to get the info to. So as I said, you know what the problem says anyway. I'll do another video like this on the Case Study 2 and major essay thing. So look, for the moment I might say goodnight to you all. For me it's getting late, nearly 9 o'clock. And I shall get this up as fast as I can. Hopefully it'll be Saturday at 9 PM. I might get it up by tonight or Sunday morning. Why am I telling you this? You're either watching it or you're not. Anyway, take care. Lovely to see you all, even though I can't.